I'm Eli Sluter with Sluter Law Firm. I'm licensed in Arizona, New Jersey, and Pennsylvania. However, the information we're going to cover in this short class is not state specific, and the terminology may vary in your state. Today we're going to talk about living trusts. Again, part of all the estate planning can be very confusing. There's a lot of terminology, such as what is a living trust, what is a trustee, what is a beneficiary, and you may not have even heard of this one before, but what is a trust protector? So those are the type of things we're going to cover today. Again, this is just information. It is not legal advice, and no attorney-client relationships being created by you watching this, etc. So what's the difference between a will and a trust, right? This is a question that I'm often asked. The short answer is, one, a will is a set of instructions that deals with your assets after your death, how they're to be dealt with, who they're to be distributed to. The other, a living trust, holds your assets in trust prior to and continues to hold those assets after your death. With your will, you'll have an executor. This person has to go to the court, open probate. Everything that is filed with the court is public record. Depending on which state you live in, how formal or informal the probate process is, will determine how much of your information will be made public. And in your will, you can create trusts upon your death. These are called testamentary trust. But when you do, those trusts are still administered through the probate process. So you can still lose some of the privacy that you would gain by being proactive in forming a trust. And that's basically it. A living trust, setting up a living trust now, is a proactive approach. It transfers your assets while you're still alive into, let's say, like a container or a box, something that's going to hold them for your benefit. When you pass away, no probate is required for the bulk of your assets, right? Anything that has been proactively transferred into the trust, if the trust has been properly funded, as it's called, then everything is done privately, and there's no court proceedings, there's no court supervision, filing fees, and all these types of things. The trustor, this would be you, right? Sometimes called the settlor, is the person who transfers the assets to a trustee, right? So when you transfer title to your trust, it's going to be titled as, John Doe as trustee of the Doe Living Trust, dated such and such date. That's how it's titled. These assets are then held in trust for the benefit of other people, right? And it could be the same person. If it's your trust and it's a living trust, you are the trustor, the trustee, and the beneficiary, right? Beneficiaries get to enjoy the benefits of the assets, usually the use, the income, and can invade the principal. You can also name a trust protector. This is someone to watch over the administration of the trust assets. They can, at a minimum, typically can remove or replace a trustee that's not doing an effective job, or is not being honest, something like that. The trust protector, sometimes called a trust advisor, really the names are somewhat interchangeable because regardless of what you call them, they're only going to have the power that the trust gives them. So here you are, you're the trustor, you have your assets and you want to set up a trust. So you're going to transfer those assets into, let's say, a box, right? They're going to hold the assets, and then the trustee is whoever's carrying that box, so to speak, and they control the assets. However, the trustee has very strict fiduciary duties to preserve and manage those assets to the best of their ability for the sole benefit of the beneficiaries, right? The beneficiaries would be you and your family primarily, then your children and their families, and down the line. You can set up so that your trust, anything that is distributed from your trust to, let's say, children, can be held in trust until they're a certain age. You basically just have a lot of control as to how those assets will be distributed and who will get to enjoy the benefit of them. So let's talk about the pros and cons of using a revocable living trust. First, the pros. The big one is avoiding probate, right? Not having to go through the state supervised administration of your estate and distribution of your assets. The trust owns your assets, and the trust continues to own your assets after you pass away. You just simply have a successor trustee that steps into your shoes, and if you are the trustee of your own trust. It's important if you own real estate in other states, because otherwise you have to open probate in each state where there's real estate owned. It can be very helpful to let your family get immediate access to cash, other assets that they may not have access to right away if they weren't held in trust. Basically, avoiding probate is much less stressful for your loved ones, right? Using a trust also can help you avoid your family having to go to court to have a judge adjudicate you as incapacitated. The trust can provide a process for doctors to sign off on that without having to get courts involved, and that can be very timely and expensive. And so avoiding that can save you a lot of money down the road by being proactive with a trust. Also, privacy, as we talked about, probate being a public proceeding, formal versus informal. More formal states like Arizona require typically an inventory of the assets, where in New Jersey, where it's less formal, you don't have to disclose as much information, so there's less information that's made public. And finally, it forces you to get your act together, right? You have to get your assets organized when funding the trust. You have to figure out where everything is, track down those stock certificates for the stock that your aunt gave you for your wedding, for instance, or cars, everything you will be get organized and when you fund the trust. So what are some of the cons of using a revocable living trust? The big one is it's more expensive up front right now, right? It costs more to set it up, and then you have to fund it. Typically takes more legal fees. But ultimately, in the long run, by avoiding probate and possible guardianship proceedings, it can save money and obviously headaches. There's more hassle, right? Because once you sign your trust, you have to fund it. And that means contacting banks and changing title to things like cars and boats, and having business interest title changed, and any real estate. You have to have deeds prepared and recorded. Also, you still need a will, right? It can just be what's called a pour-over will, and this transfers any assets that you forgot to put into your trust or failed to put into your trust. It will pull them over into the trust. And also, you do need your will if you have minor children to nominate permanent guardians for them. Also, challenges, and it depends on the state. Certain states have different laws and time periods as to how long somebody can challenge a trust versus challenging a will. But with a trust, you do again have that privacy that only those people that are named beneficiaries in the will have access to the will, or to the trust rather, versus a will. Anybody who is in line to be an heir has a right to see the will. So far, what I've been talking about is revocable living trusts primarily, and now I want to touch on the difference between those and a different type of trust known as an irrevocable trust. What's the biggest difference? Well, obviously, by their names, revocable means the grantor can revoke it, can change the terms, can amend the terms of the trust, change beneficiaries, and have basically control over everything. Whereas once it's in an irrevocable trust, the terms cannot be changed by the grantor. Only way they can be changed is if everybody involved, the beneficiaries, the trustee, all agree. With a revocable, the assets can be sold, can be taken out, the trust can be shut down in essence. The grantor still retains that control, whereas with an irrevocable, once it's signed, the terms are set, and only the trustee can sell the assets or take them out of the trust, and you're typically not the trustee of your own of an irrevocable trust that you set up. Another reason you may want to use an irrevocable trust over a revocable trust is to avoid estate taxes. However, there currently is no estate tax in Arizona, Pennsylvania, or New Jersey, the 3 states where I'm licensed. And the federal levels, the exemption levels for the federal level are very high currently. It's $11.4 million for an individual that they can leave without any estate tax due, and for a married couple, that doubles to $22.8 million. So using an irrevocable trust can take assets out of your estate for estate taxes reasons and for other planning reasons that we'll talk about in a moment. Alternatively, with a revocable trust, you may want to keep assets in your estate, especially if they're going to be below the exemption levels, because when they're in your estate, then there's a step up in the basis, right? And the basis in an asset is what was paid for it by the person that bought it, right? So if your parents bought a home for $50,000 years and years ago, you haven't lived in it for years, they both pass, you inherit it without this step up in basis. Let's say the house was worth $550,000 when they passed away. Then when you sold it, without the step up in basis, you would owe capital gains taxes on $500,000 of the proceeds from the sale of that home, versus with it being in your parents' estate, it gets a step up in basis to the value when they pass away. And so when you inherited it, you would inherit it with a stepped up basis of the $550,000. If you sold it, you wouldn't owe any capital gains taxes on that. So these are important planning considerations that need to be taken into account. There's a lot of other reasons why you might want to use one versus the other. Obviously with the revocable, the avoid probate, avoid a headache for your loved ones is a big one. Privacy we talked about. Planning for mental disability incapacitation. This is your future mental disability, so you have the conservatorship, guardianships in place. And also if you have what I call mixed families, right? You or your spouse have children from a previous relationship, and you want to make sure that they're cared for or taken care of in your inheritance. And there's no chance of them not getting what they're due, what you want them to receive when you pass. For irrevocable, other reasons besides the estate taxes would be protection from creditors. You know, these are your future creditors. Once you put an asset in there, then it takes it out of your estate, it's out of your control. For Medicaid planning, for instance, the nursing home, they're going to look back 5 years. This is how long they currently look back. So when you put, let's say you put a home into an irrevocable trust for Medicaid planning, that's not going to be fully effective until 5 years after it's done. So it's very important to be proactive if you're concerned about Medicaid nursing home expenses. Also, a lot of states like New Jersey have estate recovery taxes, liens that they'll put and recover all the funds that they've paid for your parents. Let's say if they did receive any Medicaid benefits, then that state can put a lien on their estate and get paid back in essence, for instance, when you sold the home. Other reasons you might want to use an irrevocable trust is for special needs, or spendthrift for children. Maybe they're adult children, but they have not necessarily developmental issues, but maybe they have a gambling problem, or in a rocky divorce, something like that. You want to make sure that those funds will always be there for their benefit, but that they can't access them to spend them recklessly, and their creditors can't access them. And finally, sometimes you may want to set up an irrevocable trust for your children, not a special needs trust, but still a spendthrift creditor protection type trust. That funds that go into that trust can be used for their education, their clothing, their healthcare. But for instance, like a business owner, there may be a reason that you want to make your children's trust a 5 or 10% owner of the business for creditor protection for yourself and long-term issues that are outside the scope of this. And so that children's trust, like I said, you can spend it on their health care, buy their school books, buy their school clothes, and things like that. Grandparents can leave assets, put assets in there, things like that. And whoever the trustee is, typically you would be the trustee originally. But if something happened to you, then the successor trustee would step in and make sure that the children were taken care of using that, the children's trust. And for instance, you may have life insurance. Life insurance is another reason that we talked about the exclusions at the federal level. If somebody has a lot of life insurance, you might want that life insurance to go into an irrevocable life insurance trust and take it out of the estate and be there for sure for the benefit of the children. So those are just a few of the reasons and differences between revocable and irrevocable, and the reasons why you might want to use one over the other. So there you go. I hope you found that informative. Thanks for watching. As always, if I can be of any assistance, please reach out. You can call or email me, or go to the Facebook page and schedule an appointment or a phone call at a time that's convenient for you. As always, I'm here to help you with anything business transactional related, contracts, drafting, reviewing, real estate deals, trademarking, protecting your brand. I'm basically a virtual in-house counsel for business owners, but it can help anybody with their estate plan. So as always, if I can't help you, I will find you somebody who can. Okay, thanks.